Welcome to the Exhibit A podcast.
Hello, and welcome to Exhibit A, our firm's podcast where we discuss various family law topics that are hopefully useful to the public. Today, we're going to talk about the topic of modification of child and spousal support and the inability to pay. And specifically, we'd like to provide you with some useful information, but also we want to talk about this in the context of COVID-19 and the court closures. So today I have my guest, Anthony Lay. Good morning. How are you?
Good morning, Casey. How are you?
Great. Thank you for joining us. Obviously, we are complying with the governor's orders and we are proceeding virtually. And I think we're prepared to do that. So Anthony, let's get started. I want to talk to you about this. Can you talk to our listeners and viewers about do you still have to pay child and spousal support if you've lost your job? And I think that's a really relevant topic right now. So can you talk to us about that?
Yeah, so one of the things that came up in our discussions was we're seeing a record number of people losing their jobs as a result of stay-at-home orders, shutting down businesses, and that's ultimately going to have an effect on people who have child and spousal support orders. If their primary source of income is no longer available for them to pay that, well, what options do they realistically have? And the question is, do you still have to pay support if you've lost your job? The short answer is yes. A court order is a court order, and until it gets modified, which is what we're going to be talking about today, you still have an obligation to comply with that court order. We'll talk about a couple options as to how you can get those orders modified to suit your new situation with your employment and your new income level.
Okay, and so we're talking about a situation where there's a court order. What you're saying is an order is an order. It's going to continue until a judge orders otherwise. Is that right?
That's correct, yes.
Okay, so let's add to that. What if there's a wage garnishment in place and automatically this is coming out of your paycheck?
Right.
Okay, so we know that it's going to come out of your paycheck, but now you lose your job. So there's no money to garnish.
Right.
Does that mean the order goes away?
So yeah, at that point, you still have an obligation to pay regardless of whether your employer was or is no longer garnishing your paychecks. Something that's interesting that's come up, and I think is where people are going to start seeing, is that unemployment benefits can be garnished as well. So if you have lost your job and you're now receiving unemployment, it won't take long for either child support services or the court system to see that you're receiving income through the form of unemployment insurance, and you can expect that that income will also at some point be garnished.
Okay, so to unbundle what you're saying, perhaps if someone loses their job, there may not be funds to garnish.
Right.
However, the obligation to pay support continues.
That's correct, yeah. So if your wages aren't being garnished, you still have an obligation to pay that support. You would have to probably take the initiative to issue those payments to the other party to make sure that you're in compliance with the court order, regardless of whether you're receiving income from your previous employer or not.
Okay, great. And you touched upon unemployment insurance benefit, and how are benefits going to be reduced for support, if at all?
Yeah, so your overall support garnishment can't exceed 50% of your discretionary income. So that means if you're receiving, right now, it's $450 in maximum weekly support, and I think the state just added $600 on top of that. So theoretically, up to about half of $1,050 can be allocated to support. And again, until you get that amount modified to your new income level, you're still going to have an obligation to pay that. So the maximum amount would be half of that unemployment benefit.
Perfect. Thank you, Anthony. And some of the things that we talked about beforehand is, what kind of action can people take? And I think, we're going to go over some of those points,
right,
to let our listeners and viewers know what action can take place. So take it away, Anthony.
Yeah, absolutely. So one of the things that is important for people to understand, and what I mentioned already, is that you have an obligation. It's your responsibility to go in court and seek that modification. And we'll talk to Casey. What do you think is the best way to go about going in and getting that support order modified?
Okay, so if we're in a situation where you have lost your job, like we've touched upon, the order exists until modified. So it is your burden then to file a motion with the court, a request for order, and request that relief. You're going to ask for modification. The legal standard is a change of circumstance. In this situation, it's the loss of your job and therefore the reduction in your income. So you're going to have to file a motion with the court and ask for that relief. And that's especially important because if you're not paying child support obligation is not going to go away. I joke and I say death, taxes, and child support because your child support obligation is going to continue, and it's going to continue with interest and interest and on interest. So you must seek court relief, and you must file a motion for modification of child or spousal support.
Okay. And I guess a lot of people are wondering, well, what if I can't afford to pay? What if I just simply can't afford to pay child support right now because I don't have a job? I'm receiving barely enough to cover my living expenses. What would you tell someone in that situation?
I think that's a very fair question. And as a practitioner, it's a hard one. Number one, we start with, bottom line is you said, it's a court order. You have to comply with a court order. It's very hard for a lawyer to tell their client not to comply with a court order, right? Because then we know that client is going to be subjected to penalties such as contempt of court or sanctions or other types of penalties. But, once we get past that, if there is a true inability to pay, and if you're going to argue that, I tell my clients, you better be able to back that up.
Right.
Your bank accounts are subject to discovery. The other types of things that you're continuing to pay as far as your lifestyle, those things are subject to discovery. So
right.
If you can truly say, I'm unable to pay, then, there's a defense now. Because if they come after you for contempt of court, which we'll touch upon a little bit later,
right.
then you can at least argue inability to pay. So what you're going to do is, number one, I think you're going to reach out to the opposing side or the opposing counsel and say, I have the inability to pay. I lost my job. Here's my proposal for a modification. Right. If you want to be super reasonable, it's a temporary modification, and I will stipulate that I will inform you as soon as I get another job. And you're going to have to file that motion as a backup. If there's no agreement, you're going to have to go to court and seek that modification. So, if you truly cannot pay and there's no money, then perhaps the payment is not going to be made. I always tell my clients to make a good faith payment, of $50, $100 or something, right, just to make sure that you're at least making good faith. And you better not be paying, like I've said before, you better not be paying your country club membership or your Ferrari payment and not pay your child or spousal support.
So you're saying don't be ordering lobster dinners every single night from Uber Eats if you're not able to pay your child support, correct?
It's not a good look, so please.
Okay, and one of the questions I think that people are going to also have is, well, you said to go ahead and file a request for order. How do I do that if all the courts are closed right now?
The courts are closed, but there are certain essential types of matters that can still go forward. For purposes of today, you should know that most firms, including ours, are continuing to operate. We're operating remotely. You can file a request for order, which is the motion that's going to get you in the door. You can have it submitted. There are certain drop boxes. We have contacts with couriers. You can mail it in. You can still submit the paperwork. You're going to get a court date. It's important to file the motion because there are certain legal ramifications associated with that, such as retroactivity, and I think we'll talk a little bit more about that. But right, it's important to get the motion filed, even if your court date is in 2 or 3 months from now, because when you get the relief, then the court's going to consider the fact that you filed your motion 2 or 3 months ago, and you have the option of requesting, back pay or a retroactive order.
So one of the things that you mentioned was contempt of court. And I think a lot of people, when they hear the word contempt of court, they think of, like courtroom TV shows where the judge is saying, I find you in contempt. What does contempt of court mean? And what effect does that have in people who have support orders that they're not complying with?
So contempt of court, for purposes of family law, it's a very powerful tool. It's one that should not be abused, obviously, and it really can't be. People throw around the term all of the time.
Yep.
it is, in the civil context, it is a quasi-criminal proceeding. So for purposes of family law, contempt of court in a nutshell means you violated a court order, and therefore you should pay a penalty or even go to jail, which is it's a big deal to do that in the context of family law. So we bring these two worlds together. If someone files a motion for contempt of court, they're saying to you, you have a child support order and you failed to pay it. And because we're in family law, the family law judicial officer is going to then bring in a public defender, because you could go to jail for this. Most times, people assert their Fifth Amendment right against self-incrimination and allow the public defender to defend their case. And what this means is that the person prosecuting the contempt is going to have to prove their case beyond reasonable doubt.
Right.
And there are very specific elements, and you have to prove each one. And for purposes of today, what's important is that one of the elements is the ability to pay. Right. And likewise, a defense to a contempt of court action is the inability to pay support. So if you can show that you were unable to afford your child and spousal support, then you can potentially defend yourself on this claim. And if you want to stay quiet, which you're entitled to do by the Fifth Amendment, then you produce bank statements and other evidence to show that X amount of money was coming in, and I could not afford this payment because I lost, I no longer had an income coming in. So in a nutshell, that's what contempt of court is. And we're always trying to make sure that our clients comply with court orders.
Do you expect that we're going to see, I know a lot of people worry, are people going to be arrested or going to jail for not paying their child or spousal support if they've lost their job?
If someone is found guilty of contempt of court, the judge is going to determine whether they lost their job or not.
Right.
The question is, did they have the ability to pay? I've seen situations where someone lost their job, but they had other sources of funds, income, and the ability to continue paying. That's not a good enough case to say, I cannot pay. If someone truly violated a court order, they might go to jail. If they simply lost their job and there's a modification, they're not going to jail for not paying their support. They may go to jail if they're found guilty of contempt of court. But that's in a nutshell. I think at the end of the day, the important part is to respect the procedure and understand if someone files a motion for contempt of court against you, you need to seek legal counsel.
Got it. So what Casey had mentioned previously also regarding retroactivity, and we're going to get into how does one actually modify a support order. One of the things that I tell my clients, right off the bat, if there's been any kind of change in employment or change in income, is that file right away. And the reason being is that by filing right away, you preserve the court's ability to issue an order that operates backwards to the day that you file. And this is especially important because with the courts being closed right now, you're probably not going to get in front of a judge for many, many, many months until at least the court resumes its regular operations. These types of support modifications aren't considered the types of emergency orders that the court is going to hear on an emergency basis. So it's important that you preserve that right to retroactivity, meaning that when you do eventually get in front of a judge, that order is going to go all the way back to the date that you file. So think of it as a kind of a running deadline. The longer you wait to file, the more amount of time that you're not going to be able to go and modify those orders because your current order is going to continue to be in effect.
Okay, perfect. So that really flushes out what retroactivity and how important that is and how useful that is.
Yeah.
So what I want to ask you though is, what about a situation where a visitation schedule has changed? So we have the court order, it's outlined, X, Y, and Z is the visitation time, and people amongst themselves decide that they're going to change that, okay? Right. And for example, one person is spending substantially less time than what's on paper. So my question for you, Anthony, is how does that affect a child support order? Does it automatically change, for example?
Yeah. So that, retroactivity is going to apply to not only income or a change in income, but any changes to your custodial schedule. So your child support order is a guideline formula that the state of California has kind of, set forth as this is the appropriate amount of support based on two primary factors. Ultimately there's more, but the two main ones that they'll look at are your income and the amount of custodial timeshare that you have. And what I also tell my clients is the court doesn't know what's going on in your case if you're not bringing matters before it. So regardless of whether you have stipulated to an alternative schedule, this court's still going to be of the belief that you're still operating under that original schedule. So if you're going to modify your support order based on a new schedule, it's something that you should look at in terms of retroactivity as well. The longer you exercise that schedule, the less you're required or more you're required to pay support, depending on what that new schedule is, if it deviates from the one that you've been exercising previously.
Perfect. And that outlines a general principle. Now I want to acknowledge kind of the context being, that we're all in right now, this pandemic. What if you are ill and you are unable to, for example, work and exercise your regular visitation, or you're caring for a family member?
Right.
How does that impact both your custody visitation order and your child support order?
Yeah, so this is a little bit tricky because I know that with the COVID-19 modifications, the stay-at-home orders, a lot of people are modifying their custodial schedules to kind of suit the current situation. The question that I think the court's going to have to ultimately answer is this just some temporary modification, or is this going to be the schedule that's going forward? If there's a temporary incapacity of one person, say, medical issues that arise, and they're not able to exercise visitation for a certain amount of time, the court can take that amount of time into consideration in modifying the order. But I think ultimately what's going to be more important is has there been some sort of permanent change to the custodial schedule? What if one parent can no longer take care of the minor child? Well, that's also going to factor into the court's determination of what that guideline support should be. So there's no clear answer. You're going to have to probably argue it as best you can, say, you know what, this is just a temporary arrangement. Once I'm back to 100% and these orders are lifted, then we can go back to our regular schedule. Or if this is going to be a permanent change, you'll have to provide evidence to the court saying, you know what, this is the way it's going to be now, going forward, regardless of whether coronavirus is still going on. This is the schedule that we're going to use in order to determine the support amount.
Great. And Anthony, I'll say that judges are humans and they have a lot of discretion. So you're going to see this play out different ways.
Absolutely.
What I've seen is at the end of the day, it's about the best interest of the child and making sure that child receives everything that they need and that they receive the child support necessary. At the same time, I've seen courts, not want to punish a parent, for example, for allowing some flexibility. We don't want to punish that parent that, got ill and was unable to take care of the child.
Right.
We don't want to punish them by now using that as the newly established status quo.
Yeah.
So I think, it just depends which side you're on, how you're going to build your arguments, but also, I think it can play out differently depending what judge you're in front of and what the specifics are.
Exactly. I think the reason is going to be very important. If there's been a change to the custodial schedule, it's not just kind of saying, you know what, this is just the new percentage. Why was that new percentage entered? What was the circumstances in which that new percentage was entered? And is that something that should weigh against one party or not? Ultimately, that's going to be up to the judge and depending on the facts of that particular situation. I don't think anybody's going to fault anybody if they're not able to exercise time because they're taking care of a family member or who is ill, or having to modify their arrangements as necessary.
Right. And, I think people would be really interested in, just to close up this topic, and I want to ask you, Anthony, if someone wants to file a modification of support, do they have to hire an attorney?
Yeah, so you don't actually need an attorney, but we always recommend one. There's a lot of nuances to these types of cases. And one of the things, the benefits that having an attorney can do for you is to get a very good estimate of what the court's orders are going to be. We have a lot of experience in working in these types of cases, so we're familiar with the filing process, the information that the court's going to want to look at, the supporting evidence, all of that, and we can give you a very fair estimate of, based on the totality of the circumstances, as to what the court's going to ultimately order. So you can make a decision at that point whether it's worth pursuing it or not. Now, I understand that obviously with the current economic situation, attorneys may be out of reach for certain people. And to that extent, there are, self-help resources. I would say the most important thing is don't just do nothing. Don't just sit there and expect that things are going to happen on their own. You have to take some sort of action regardless of whether you go with an attorney or not. We always recommend one, but obviously if you can't, then it's incumbent upon you to take that step and make sure that you're acting upon your rights.
Perfect. And what I tell people is that, it's very easy to say, well, California has a mandatory child support guideline.
Right.
Sure. But every single factor that goes into that guideline is there's an opportunity for advocacy. There's an opportunity for an argument. So what we do when we go to court is we go side by side with opposing counsel and we advocate every single factor that goes into that calculation to make sure we get a number that is favorable for our clients and something that they're actually able to pay or something that meets their needs. That's child support. When we talk about spousal support, likewise, we have calculation, the distal master, but there's even more opportunity for advocacy.
Yeah.
And I think I agree with you, Anthony, that the judicial council forms are established for individuals to be able to complete them on their own.
Right.
That level of advocacy, I think you get when you hire private counsel to really review your case and try to get the most favorable outcome.
Yeah, I think something to note also is that if you're going to be representing yourself, you should understand that there is going to be an attorney on the other side, and that attorney represents the state of California and the county, whose job it is to ensure that you are paying the correct amount. So a lot of people don't feel comfortable going up as a lay person against an attorney. So, if that's the situation, maybe it is a good idea to look into having someone who's familiar with the process advocate on your behalf and do that meet and confer process to figure out what the appropriate amount of support is.
Very good.
Yeah. So basically, one of the things that also we should talk about is that there are non-judicial options available. You don't always have to go to court. And Casey, do you have any experience or tips about maybe resolving support disputes through the use of some other options?
I do, and I think as the years go on and I kind of see these cases through and through, I've developed pretty much a system, and it's very helpful to start with. Obviously you want to analyze the case and figure out what the numbers are going to look like. Like you said, Anthony, we kind of have an idea of what the numbers are going to look like when we go to court. So start there, do the work, front load the work. I start with a phone call or a proposed order to opposing counsel or the opposing side. I've already outlined what I think the number is going to look like. That has the benefit of either settling the case without the time and costs of going to court, and also you've done the work, and eventually we can sign what's called a stipulation and order, and the judge will sign it. It's a court order, and we don't have to go to court. So I start there, and I always tell people the best way to settle a case is to prep it as if you're going to court, because at that point you understand the strengths of the case, and you also know where your client's vulnerabilities are. You know where you need to tell your client to move on certain positions. So I start with that. If that doesn't work, sometimes you have to have a motion kind of in the background. Why? Because we talked about the retroactivity. That's very important. But in the meantime, there's a lot of time. There's also the possibility of settlement letters, also voluntary settlement conferences, and now there are a lot of retired judges that can be hired as private mediators. These are all the different ways that we can resolve matters before the court date comes up. And we, eventually, if we can get it resolved, then we can take the court matter off calendar. So there are options. Now, talking about the within the context of COVID, I would say, it's time to get creative. It's time to flex your negotiation skills. Right. And we all know that we can't get into court, a month from now.
No.
Therefore, we're working really hard to try to resolve these issues. I mean, on the other side is thinking, the retroactivity clock is ticking anyway. So if they do nothing, there's going to be this support order that's going to be, retroactively modified. So I think everyone's encouraged to get it done.
Right. So what would you say are the biggest advantages of using, a settlement method versus going into court and arguing?
Couple things. I would say one is, you could save some time and expense on, hours sitting in court versus sitting with a private judge, using those hours to talk about the substance of your case.
Right.
Number two, if you do hire a private judge, there are specific rules about the confidentiality. You can speak freely. If there's, a third party hired, those statements that you make are protected and confidential and cannot be used against you later. I think that's another useful outcome if you use alternative dispute resolution.
Got it. Okay, cool. That's a good kind of overview of the non-judicial options, and we always kind of tend to prefer those options because it ultimately does save our client in costs. We're not looking to earn a bunch of money just by sitting there in court waiting for the court to call our case. I think if there's an option to try to spare some of the costs by working with opposing counsel or exploring other options, like a mediator or an arbitrator, those are definitely preferable to kind of rolling the dice in court.
Right. And Anthony, I want to throw a final thought your way.
Yes.
I want you to tell, our listeners and viewers, can you tell them, because I know a lot of people are really interested to know, if they don't pay their support, can the other side come after their assets, their property, their bank accounts?
So short answer is yes. If you are well in arrears in your child support or spousal support, it is a possibility that the court can attach liens onto certain bank accounts, personal property, vehicles, even possibly your home. So it's a very serious situation. Now, I haven't seen that as the first option that the courts will use to try to recover on what's called arrears. Arrears are basically back payments that are owed for support. But if there's a continuing trend of failure to oblige by court orders, or like I mentioned before, if you're now in a different income situation but you haven't done anything about it, and each month that goes by you're getting deeper and deeper into arrears, you can expect that at some point the county of Los Angeles or opposing party is going to want to try to recover on those arrears, and to the extent that liens can be attached, that's definitely a possibility.
Perfect. Thank you for that, Anthony. And thank you for joining me in this discussion.
You're very welcome.
Thank you for joining us on Exhibit A, and we'll see you next time.
Thank you.
For more information, visit us at PasadenaLawOffice.com.